Well, good morning, everybody. Hello, it's Thursday again. So it must be time for the New Possibilities Hour. Welcome to We'll Work for Food, the New Possibilities Hour. Today is March 9th, 2023. And at least here in California, spring is in the air, even though it is very cold. That said, very cold. Some of you will make you laugh as I see Neil here laughing. But anyway, today we have a very special speaker. He's coming to us from Ohio. He's Pennsylvania born and raised, and has lived in Ohio for, I think, about 30 years, give or take.
1987, actually.
1987. Okay, Eric Wittenberg, and his food bank is the Heart Market, and Natalie will put that information in the chat. And for any of you watching it later on the video, it will be there with the video. So Mr. Wittenberg he's a graduate of Dickinson College in Carlisle, Pennsylvania, and the University of Pittsburgh School of Law. He was also admitted to the Ohio Bar, and then also is part of the he's admitted to the federal courts in Ohio. He is a mediator, obviously an attorney, has extensive experience in handling business, real estate, and construction claims of all types. He has served as a sole arbitrator on construction and construction warranty claims, and has mediated a wide variety of cases. And he is definitely an advocate for resolving cases in a cost-effective, creative manner. One thing that I think was a little interesting about his bio here is that he's an award-winning Civil War historian. And I suppose what better place than where you live to focus on the Civil War. He's the author of 23 published books and more than 36 articles on the Civil War. So we'll have time for questions later. Maybe a question might deviate to the Civil War. But for right now, we're going to go to divorce wars in business situations. However, wait, before I turn it over to Mr. Wittenberg, how could I forget what's Jeff's favorite part of the program? And he is still on his honeymoon. He'll be back next week. Natalie, what's our number today of donations to food banks around the world, of which we've been told?
Good morning, Jean. Thanks so much for moderating We'll Work for Food. Your work is much appreciated. Also much appreciated are all of the people around the world who donate to their local or our sponsored food banks. We have been told about $369,235.56 in donations, which is substantially more than 4 million meals served worldwide due to the generosity of the resolution industry professionals.
Wow, that just gives me goosebumps. That's just fantastic. And so thank you all for your generosity. Thank you, Mr. Wittenberg, and thank you to everybody who's ever spoken for supporting this initiative. So that said, Mr. Wittenberg, the floor is yours. Thank you.
Thanks, Jean. And before I get started on the substance of the talk, let me just briefly mention the Heart Food Pantry for you. Heart Food Pantry is located in Reynoldsburg, Ohio, which is a suburb of Columbus, not far from downtown. It's about 12 miles from downtown Columbus. It is about 20 years old. The food pantry, and I just coincidentally happened to bump into the executive director yesterday, and she told me that they're currently serving 1,500 families, which is quite a lot. And any contributions that anybody wants to make will be gratefully accepted by them. They're doing good work, and the numbers have increased since the beginning of the COVID quarantine and when the world shut down until now, from about 400 families a week to 1,500. So there's a need, and they will appreciate anything you want to donate, and I thank you in advance for doing so. I want this to be something of a dialogue. I'm not inclined to spend an hour lecturing at you because I don't think that's a good use of anybody's time. What I'd like to do instead is to describe to you the topic that I was asked to speak about, which is business divorces. And then I can talk to you, I'll tell you a couple of war stories that demonstrate the point, and also share some tactics and techniques with you. But then for the later part of this discussion, I'd like to kind of throw the floor open to conversation. So let me begin with the concept of what is a business divorce? Let's say that Jean and I go into business together. And after establishing our company and being up in business for a couple of years, we suddenly realize we can't be in business anymore. Jean's goals are very different from what mine are. What Jean wants to see the business do in terms of growth and expansion are different from mine. And we realize that suddenly we no longer are on the same page and are no longer moving in the same direction at the same time. Many times these can lead to really ugly situations, and they can be every bit as ugly and painful and unpleasant as a domestic relations divorce. The big difference being that in this instance, the child is the business and not flesh and blood. And I want to share a story with you to put some flesh on these bones. It was actually one of the things that motivated me to begin to develop a mediation practice. In late 2019, I was approached and asked to assume representation in what was very quickly became obvious was going to be a business divorce. The company at stake had been started by a Russian immigrant who is an engineer and an inventor. He is not a reasonable fellow. He is, let's put it this way, in testimony at a hearing before the court, when I asked him why he thought that the company needed him to proceed, his comment was, "I am the company. There is no company without me." So imagine being in business with somebody who your partner has that attitude, and eventually his partner, and there are longstanding ties between the crazy Russian inventor and his former business partner. The families were friends back in Russia even before they immigrated to the United States. So the son of this other family became the CEO of the company and was responsible for day-to-day operations, marketing, et cetera. And he blew the thing up very quickly. It went from being a complete startup with the time that Mike joined the company to being a Fortune 5,000 company in just over 18 months. But Mike eventually realized that working with this crazy Russian inventor was not something that was going to be sustainable, because it was an unequal, unfair, and abusive relationship. And Mike finally had enough. So I was retained to represent him and the company against the crazy Russian inventor. There were two other investors from the outside who were venture capital types, and they were on the side of my client. And we filed a complaint with the court seeking the judicial dissolution of the company and the appointment of a receiver. And eventually, I then filed a motion to accomplish that. And the court scheduled a hearing to ascertain whether or not this company should be judicially dissolved. And we had a 2-day hearing before a magistrate who got to see our Russian friend in all of his glory. On 2 different occasions, she had to call a recess so that opposing counsel could take him out in the hallway and tell him, even if you don't like a question, if the court doesn't sustain our objection, you have to answer it. He would refuse to answer. So that the magistrate got to see everything about this guy that my guy ultimately elected not to go into or remain in business with him. So there was a intellectual property involved, multiple patents, and it took the magistrate issuing a written decision after a 2-day hearing in the middle of COVID. The hearing was held at the end of August of 2020. So it took the magistrate writing a written decision saying this company should be dissolved judicially because its continued purpose is frustrated, which was part of the LLC statutes here in Ohio until Ohio adopted the Uniform Limited Liability Company Act the following year. And it was only then, after each side had spent somewhere between 60 on my side and in excess of 100,000 on the side of the crazy Russian inventor, for him to get reasonable about settling the case. It took that. And with that, it made me realize there's got to be a better way. There has to be a better way to resolve these things. Sure, it was nice making a $60,000 fee. Sure, it was nice winning a case against a guy whom I respect a great deal and is considered one of the best trial lawyers in this part of Ohio. That was all great. But we could have gotten to the same result much earlier had the crazy Russian guy been reasonable. Now, that is obviously a critical thing because reasonableness is always an issue. And if the other side isn't reasonable, then it's awfully difficult to have a dialogue. And in his case, it took him realizing he was on the verge of losing his IP forever for him to realize, okay, maybe I need to change my position. And that's an extreme situation, but it's a real life example. And it's what got me thinking about, is there a better way? And if there is a better way, who in this area is working to resolve these kinds of business divorce cases? And I quickly discovered that the majority of the mediators who are lawyers who work in this area are either doing domestic relations work, which I don't do, or they're former personal injury lawyers doing personal injury stuff. There was only a couple of attorneys in this area who are business-oriented lawyers like I am. I'm a business and real estate guy. I do transactions and I do litigation. I was a sole practitioner for 21 years. So you have to do both when you do that. So I said, okay, there's a niche here and I want to fill it. So that was when I decided to commence seeking some mediation training. And I've been through in excess of 50 hours of formal training. And at the end of 2021, I launched a business that's called Ironclad Dispute Resolution Services. And I provide services as a neutral in two fashions. One is I do serve as an arbitrator. They are mostly construction cases. Many of them arise out of new home warranties. If you're not familiar with those programs, many times when you build a new home, you get a warranty, and the warranty contains a mandatory arbitration clause. And those arbitrations are typically administered by a third-party company. And I handle all of those arbitrations in this part of Ohio for the largest home builder in Central Ohio. So I serve as a neutral doing that, but I also serve as a mediator. And I try to limit myself to cases that are within my sweet spot. And by that, I mean, I try to do things that are business related, that are real estate related. Sometimes they are construction related. Sometimes they have a little bit of an employment aspect to them because I've done a fair amount of employment law over the course of my career. And tomorrow I am mediating a case where someone alleges that she was terminated from her job and retaliation for whistleblowing. So that's going to be an interesting one. That's a federal court case, and it's going to make for an interesting day. At the same time, I still practice law. I still am working as an advocate. So I maintain my ability to see both sides, both as a neutral, but also as an advocate. So how do we handle these business divorce cases? That's really the question that we're all here to answer. And the answer is that you've got to find a way to find common ground for people to come to some resolution. And part of that requires getting them to understand that they have a common goal. The common goal is you don't want to be in business together anymore. We need to find a feasible and functional way to separate you that doesn't destroy both of you or destroy the business in case one of you wants to continue on with it. So one of the things you've got to do is get to some understanding of what the objective is. Are we going to dissolve this business and just have it go away? Is one party going to buy the other one out? And if the other party is willing to be bought out, what are the terms of that buyout? And because these things can be very emotional, and certainly in the case of Leonid, the crazy Russian inventor, he was unable to separate his anger at being sued from being rational, like I said, until he was staring down the barrel of a gun and seeing that his IP that he had worked so many years to develop and that he'd gotten patents for were going to be sold out from under him if the business wasn't able to be saved through one party or the other, carrying forth with it. And my guy, to his credit, said, I don't want the business. If he wants to continue with it, we'll continue, let him continue with it. Let us just come to terms on how I'm going to leave the business and he can have it. And the upshot of that story is my guy ended up leaving without being paid a dime for his stock. And in return for which he was relieved of liability from an SBA loan and given indemnification. And that's how we ultimately got the case settled after spending $160,000 worth of legal fees. Could we have gotten that done much earlier if the Leonid, the Russian inventor, had been reasonable? There's absolutely no question. And the parties would not have had to spend so much time and so much emotional energy and so much in the way of financial resources to get to an outcome that could have been had right at the beginning of the case, because I told Leonid's attorney right at the beginning, my guy's willing to leave. My guy's willing to leave without being paid for his stock. He's willing to leave in return for indemnification. Instead, Leonid filed a counterclaim and we had to work our way through all of that stuff. So the first step is you've got to identify the goal. What's the goal? Is the goal the dissolution of the company, or is the goal for one party to carry it on without the other? Once you identify that goal, then it's helpful to have the parties have an understanding of what the precise value of this is. That's where the working with an outside expert, a business valuation expert, can be extremely useful. It can be anybody from a CPA to somebody who does expert witness work as a valuation expert. And in our instance, the company CPA gave us several different valuations. It was a book valuation, there was a going concern valuation, and we took the median of those by agreement of the parties as to what the value of the company was, so that we could at least understand what the baseline was and get a sense for what the IP might be worth on the open market if the business was dissolved and then the IP taken and liquidated. So once you have a basic understanding of what the value of the business is, then you've got to identify what are the stakes. So the stakes are who's going to continue the business, who wants to exit. Or are we going to dissolve the business and split up the proceeds? I've got one of those going right now where the two partners are going their separate ways. They've decided to dissolve the business, and the only issue is working out the distribution of the company's assets, who gets item A, who gets item B, and so forth down the list. There's not going to be a lawsuit. It's not that kind of a case. It's really just helping them come to a resolution and then documenting it with an agreement. That's how I'd like to see these things go, but we're all realistic enough to understand that that's not necessarily the case. So once you identify what the objective is, then you've got to come up with a strategy to help the parties get there. And one thing that I have found to be particularly helpful and useful in trying to mediate this type of case is to get the parties to focus on what are the relative weaknesses and strengths of their cases. And many times that involves me as the mediator asking some difficult questions. And I always insist, by the way, that the parties provide me with a confidential mediation statement in sufficient time ahead of the mediation for me to spend some time going through it and really getting a handle on what are all the issues here, what's agreed on, what's in dispute, what are the legal positions of the parties. I spent most of my morning doing that this morning for the one I'm doing tomorrow. And now I think I've got a solid understanding of that case. Point being that you can't be helpful to people and give them a reality check as a neutral unless you understand their case. So it's critical to be well prepared for these sort of things. You've got to read what they give you. You've got to understand what the issues are. If you have a question about a legal issue, take the time to look it up. Make sure you understand what the legal issue is. I will then, after doing a brief introduction, I don't have parties do opening statements because I find that just inflames things. I will do an introduction. The introduction is typically laying down some ground rules, talking about the fact that anything that's said in a mediation is absolutely privileged, that I won't relate anything that I'm not given authority to relate to the other side, and that my role is to help them find common ground, and that in the process, I'm going to ask difficult questions. I'll then split them up, and I'll typically start with the plaintiff, if there's a lawsuit pending, and I will walk through what I believe are the strengths and weaknesses of their case, typically focusing on asking questions, typically asking questions about what I perceive as weaknesses in the case. My hope is that by doing that, and the objective of that is to get them to identify that maybe it's not a slam dunk case like they think it is, and that maybe it's necessary to find a way to resolve this. And I'll share with you what I was told when I was a young lawyer, and I am no longer a young lawyer. One of my bosses came to me and said, "Wittenberg, do you know what a good settlement is?" And I said, "No, tell me, boss." And he said, "A good settlement is one that both sides walk away from equally unhappy." And I thought about that for a little while, and it made perfect sense to me. Each side has given up something to get something. You're taking or giving less than you want. If you're taking less than you want, or you're giving more than you want, in order to get a guaranteed outcome. Because I always explain to people, including in mediations, that the minute that you decide, okay, we're not going to settle this case, it's going to go to trial, the minute that you put your fate in the hands of a third party, you lose the ability to control the outcome. And juries are not known for being predictable. Sometimes they are, but sometimes they're not. Sometimes judges will take forever to make decisions. We had a decision came down in a case earlier this week that was purely a question of law. It was the interpretation of an easement. An easement, by the way, that's been around since 1897. The parties stipulated the facts. It was submitted to the court on briefs. This case was filed in June of 2019, and we got a decision on Tuesday. Almost 4 years into the case. Discovery had been finished 2.5 years ago. Constantly getting asked by the client, why can't we get a decision? Why can't we get a decision? I don't know, Mr. Client. I don't know what to tell you. I can't control what the judge does. So I always try to make sure that people understand that taking a case to trial, while it may be necessary sometimes, because there are some disputes that just can't be resolved short of going to trial, is not the best outcome. And that if they want to be able to control their narrative, they have to be willing to come to some sort of an agreement. And that by definition means compromising, and compromising means giving up something to get something, and walking away from a good settlement equally unhappy. And I'll explain that to both sides. I'll walk them through it. I'll walk through all the costs that I can anticipate being associated with this business divorce and what I think it's going to cost to take a case like that to trial, because I have experience with it. I know what it costs. And then, having done all of that, I will then begin to explore with them, what is not the outcome you want, but what is the outcome you can live with? And we start with the outcome they want, with the objective of working toward what is the outcome they can live with. I'll then get authority. I'll go talk to the other side. And I'll do the same, pretty much the same exercise with the other side. And eventually, as part of that conversation, I will relate what I've been given authority to relate in terms of an offer, and we'll discuss it. Many times, parties will ask me to leave the room so they can talk to their clients without me being present, despite the privilege. So I'll excuse myself. I'll let them know I'll be in my office, and they should just come get me when they're ready. And we're fortunate here because we have several conference rooms, but so that I'm able to separate people, and not just by having them in separate conference rooms. The two conference rooms are separated by probably 30 or 40 yards worth of space. So if the one that's on the other side of my wall here, if they're in there talking, the people in the other conference room can't possibly hear them. So somebody will come get me and I'll hear what they have to say, and we'll go back and forth. Every once in a while, we'll reach a point where we're not able to come up with a solution along the lines of what the parties have indicated they want. And that's where the experience of handling these kinds of cases becomes critical, because you think about, okay, well, what have I done in the past to resolve these kind of disputes? And that's where it helps to be creative and to think outside the box and come up with solutions that are not necessarily things that they've thought of. And that's something that only comes with experience. We'll try that. We'll try some creative solutions. I like to call it taking a walk in the woods. And sometimes we'll take a walk in the woods. And sometimes that doesn't work. And the last one that I did, the parties, it was a breach of contract case. It was a business dispute between a prime federal contractor and a sub. And the parties came to the mediation $1.2 million apart, both of them saying, oh, you need to pay me. And after 3.5 hours of getting nowhere with that, I said, well, I've run out of creative ideas here. So all I'm left with at this point is a mediator's number. And I explained to them what a mediator's number was. The lawyers already knew, but I had to explain to the clients. And they both said, we would like for you to do that. I said, okay. I said, I'm going to excuse myself. I'm going to go in my office and think for a few minutes and come up with what I think is a good number. And I'll type that up, I'll print it out, and I will present it to both sides. And if you both accept it, then the case is settled. And if you don't, then we're done. And you can go on about your way and litigate your case until the cows come home. And this was a case where it was very clear to me that if it were going to go to trial in federal court, given the amount of money involved in these contracts, this was going to cost a couple of $100,000 for lawyers' fees to get it done. In dispute, among other things, were 2 months worth of invoices that the sub had tendered to the prime. Between them, they were approximately $350,000. There's no question the services were rendered. The prime was denying paying them because it claimed it had set-offs because of the sub's breaches of contract. So I sat down and thought, what's a fair outcome here? There's nobody disputing that these 2 invoices were owed and that the monies were earned. Same time, I think there's some validity to the prime's claims. So the number I came up with was, for my mediator's number, was 1 month worth of invoices, the sum of $175,000. I typed it up, I handed it to both sides, and to my great surprise, they both said yes. Now, it took us a little while to come up with the payment mechanism because the prime wasn't in a position to stroke a check for $175,000. So we had to work a little bit on terms, but eventually we came to an agreement on terms. And after a little over 4 hours, in a case where the parties were $1.2 million apart, where both sides were saying, you pay me, I got the case settled. One of the ways I got it settled was to make the prime understand that he was going to spend as much on attorney's fees to take the case to trial, go through all the discovery, and then take the case to trial, that he was going to pay that 1 month's worth of the invoice to end it today. And that's how I sold it, and that's how I got it done. And that's what I often do in these kind of business divorce cases, because I want the parties to understand what the ordeal is that they're in for. And sometimes it takes that mediator's number, and it takes me explaining why I came up with that mediator's number to get to the point of being able to resolve the case. So I've spent a little over half an hour explaining this stuff. I'm sure that what you've heard here today isn't all that different from the techniques that you use in your own mediation practices. I think it just depends on the subject matter that you're dealing with. And what I think I'd like to do for the rest of our time, if it's okay with you, Gene, is to have people unmute and let's have a dialogue. Let's talk about this.
That sounds great. We all have good stories and we have questions. One of my favorite business disputes involved where the CEO of one company offered to throw in after, we'd been going around for a few hours. He said he would buy dinner for the CEO of the other company and they'd had business relationships for years. So it wasn't really a dissolution of a particular company. It was a business dispute. And the other CEO accepted, and they did end up resolving, and they scheduled their dinner where the location where they would meet and when and all that during the course of the mediation before we concluded. So
isn't that interesting?
Yeah.
One of the things that the one I just described to you, the dispute between the prime and the sub, the president of the prime, who was here, he's from Georgia, he came in for it. We did this in person. Proposed to the other side, why don't the two business people talk directly? Let's leave the lawyers out of it. And the other side wasn't interested in doing that. So sometimes that's a ploy that can work, and sometimes it's not. It isn't. It all depends on how bitter people are and how resentful they are. And, let's go back to crazy Leonid. There was no way we could do something like that because the Leonid and my guy could barely be in the same room together, let alone to sit down over dinner and try to have a pleasant conversation. It just wasn't a possibility.
You say that, I'm sure we've all had, I did have that once, and the two owners of a particular business, they've been in business a long time, family, friends, the whole thing. And they asked me as a mediator and the two lawyers to leave the room. They just wanted to talk. And then they called us back in and they'd resolved it. They told the lawyers to wrap things up. I asked a few more questions, basically that thing settled because the two of them talked.
I did that once very early on in my mediation career. And this was even before I decided to start Ironclad. Our court here used to have volunteer mediation. They had settlement week, our state court. And I was a volunteer mediator for settlement week. And I had one of these cases where the two guys were at each other's throats. We weren't making any particular progress. And I said, all right, I'm going to throw caution to the wind here. I'm going to take a walk in the woods. And I said to the lawyers, I said, there's absolutely nothing to lose here with what I'm about to propose. And I said, would you two mind leaving the room? I want to talk to your clients directly. And the two lawyers looked at each other and they both shrugged and said, why not? So they got up and left. And I had one of those now look conversations with the two business people. And half an hour later, the case was settled. So sometimes it takes doing something really extreme like that to break a logjam. And if you've never tried that in your mediation practices, you might consider that sometime, because it can be a way to get through what seems to be an impasse. And as you all know, we often come to impasses doing this. And the question is, how do you break that impasse?
Right. So do we have any questions? Mr. Wittenberg would like a conversation here, and what a great opportunity we have.
And if you
Just
got war stories, please share them with us.
Or unmute yourself. Okay,
Hi,
Richard.
yeah, this is Richard Lutringer. I really enjoyed your presentation. I've done a number of business divorce cases, and several involving family businesses, which involves an entirely different set of circumstances.
That's the ugliest scenario of all. And I'll tell you about one of those in a minute.
Okay, well, I'd love to hear yours. But one of the ways I found dealing with small business, where you have two owners who work together in the business but can't stand each other anymore, where the families have been close in the past, and I asked them about if their wives know each other. Their wives can be very close. I had them bring the wives to the second session of the mediation. So my thinking was they wouldn't have to go home and tell them what they gave up, the wives, and the wives were really helped settle the case for us.
That's a great idea. I've never thought of that. Thank you. I like that.
You're welcome.
But I've got one of these family situations right now. It is a family funeral home business. The fifth generation is in the business. So we got Harry III, who is in his 70s. We got his son, Harry IV, who is in his late 40s. And Harry's son, Harry V, who is a recent graduate from mortuary school and is involved. Harry IV's brother was also involved in the business. And they had some sort of a falling out, and the brother packed up his things and left and moved to South Carolina and is still a shareholder in the company. We can demonstrate and prove that he has misappropriated well over $100,000 in corporate funds. I've got pretty good proof of it. I'm not acting as a mediator. This is one where I'm an advocate. And these family relationships are probably forever ruined. And that's a shame. It's a shame that it got to the point where they didn't involve somebody like me as a mediator before it got to the point where we're about to begin drafting a lawsuit. I don't want to have to do that. I'd prefer not to do that. We'll see what happens. Supposedly, the brother is going to come up here in May to pick up some personal items, and they're going to have a conversation. And I hope they're going to be able to come to a resolution, and that what I'll be doing is drafting some sort of a separation agreement as opposed to drafting a lawsuit. Because I'm not necessarily even thinking about the generations that are involved in that business today. I'm talking about the generations that come. And I would like to see them be able to preserve some sort of a family relationship. But I'll admit I'm not terribly optimistic. But I like your idea, Richard. Thank you for sharing that.
Okay, you're welcome. One other point I wanted to ask you about is, let's say, I mean, I've had these all settled, so eventually we don't have the court ordering dissolution. But I'm just wondering if a court did order dissolution, as crazy that is, because you might lose your bank loans, you might lose your, a lot of things are hinging on company not going to dissolution. But let's assume that isn't overwhelming. Wouldn't in some ways that solve the valuation problem, and the one side could just buy out the assets of the company? I mean, it would seem to me that I've never actually gone that far, but I'm wondering if you have and what happens in the dissolution proceeding.
Well, that's exactly the situation we were looking at with Crazy Leonid. There was a roughly $1 million SBA loan that both Leonid and my guy were personal guarantors of. And when we filed the lawsuit seeking the judicial dissolution of the company and the appointment of a receiver to liquidate its assets, that is a breach. That's a material default in the terms of the loan.
Right.
We talked to the lender and kept them in the loop in this thing all along, understanding that it could get very ugly very quickly. And the lender was good enough to allow us some latitude to try and work through this before it acted on the default. And eventually, like I said, after we had this hearing where the magistrate ordered the judicial dissolution of the company, we finally settled it. And Leonid was able to bring another guarantor to the table to substitute for my guy. And my guy eventually got released of liability. And that was the end of that. Point being that is always a possibility. And remember when I was telling the story of Crazy Leonid, I mentioned to you there was two other investors who were venture capitalist types. They were actually prepared to buy the IP and go on with the business, find different people to run it, maybe even keeping my guy on because my guy did a good job, and continuing to sell the product because the product was good and it was successful and it was popular. And I suspect that that's what would have happened. I suspect that the two venture capitalists, through a new entity they were going to form, would have purchased the IP and just kept right on going with the business. And in the end, that would have cost Leonid his life's work. And when you put it all together, that's kind of the worst case scenario, but it is a viable, at the same time, it's a viable scenario. So there's a real life example for you.
Yeah.
Mr. Wittenberg, I've received a question here in my chat for you.
Sure.
For those without historical data on cost of litigation, what are legitimate ways to estimate these costs to communicate to the parties?
That's a great question. And
That's Ishmael.
I'm assuming that means that some of our crowd here are not lawyers and not experienced with this sort of thing. So,
Well, I wouldn't make any assumptions like that. Just
okay, fair enough.
They're not all lawyers, everybody, that's for sure. I have no idea who is or who isn't, but you've got experienced mediators, arbitrators.
Sure, but that's a very fair question. And what I many times will tell people the following. I will say, if you're here to hire me to litigate for you, you need to understand that we can never, when I'm acting as an advocate, we can never assume that a case is going to settle. We have to act as if the case is going to go to trial, and we have to prepare and go through the procedures as if we're going to trial until we're not. So I will break down the litigation process into phases for them, and I will give them a rough estimate of cost. So in this type of a dispute, and I'm going to use Crazy Leonid's case as a good example, the investigatory phase, and at the time my billing rate was $325 an hour. It's gone up since then. The investigatory phase was somewhere between $5,000 and $6,000 worth of time going through documents, going through everything I had to go through, making sure that I had all my ducks in a row, doing the legal research. We then drafted and that includes drafting the complaint. The complaint was filed. Once the complaint was filed, we then did the motion for appointment of a receiver. That was another couple $1,000s. And then comes the discovery phase. And experience tells me that the discovery phase is the most expensive part of the process. And, you're talking about written discovery in the form of interrogatories, requests for production of documents, requests for admissions. And then once you get through all of that, then you're talking about taking depositions, and that's where the real cost mounts up. And in the case of Leonid, it took me, because he was so uncooperative and so unwilling to answer questions in his deposition, it took me 3 full days to depose him. 3 9-hour days. So, could be a $10,000, a $15,000, $20,000 proposition to get through discovery. Then comes the motions practice, where the parties are going to ask the court to grant them summary judgment. That's another $5,000, maybe more. And then there's the trial prep and the trial. And depending on how long that trial goes, that can be another $15,000 or $20,000. So I will always tell people, this is your worst case scenario. This is what you can expect if we have to go all the way to trial. But I also tell them that the statistics in my county here are that only 3% of civil cases that get filed in our local state court ever go to trial. 3%. So that means 97% get disposed of other ways. And of that 97%, maybe 15 are by summary judgment or other summary mechanisms, and the rest are because people settle. Why they settle? They want to come to some ability, maintain some ability to control the outcome and manage their risk. So that at least gives people some idea of what kind of money we're talking about in a sophisticated commercial dispute.
Thank you. Then, and you preface that as the counsel, as the advocate. So in response to that same question, I would take that further, that's exactly what variations on that, or what the counsel do with their clients. But as a mediator, talking how much it's going to cost to get to that point. I mean, and if, you don't know exactly how many depositions are going to have to be taken, or what motions might be planned in the future, these kinds of things, because you're the mediator, you're not involved directly in the nuances of the case. I would suggest it's certainly fair to ask the party, the way the question here was worded, to communicate to the party's costs. Just ask the lawyer, ask the party, I'm sure your lawyer has told you, an estimate of what it's going to cost to take this to trial, and then tie it back there and do it that way. Another way would certainly be, as these cases can cost, upwards of hundreds of thousands of dollars, depending on how much discovery or how much this or how much that.
Yeah, and let me just follow up with that, because one of the things that in response to one of my questions along those lines, in the case we settled a couple of weeks ago with the prime contractor and the sub, it came out as part of the conversation that ESI alone in that case was going to cost the prime, had been quoted $60,000 to $100,000 just to do the electronic stuff of sorting through emails and mirroring drives and all that kind of stuff. That alone was $60,000 to $100,000. That's how I was able to sell the 175 settlement.
Asking questions. I see, Bill, you've got your hand up, but Ishmael, you unmuted yourself. That was your question. Did you have more that you wanted to ask or clarify?
Yes, a separate question. Eric, thanks for your presentation. I wanted to ask, earlier in your career in doing the business divorces, how did you drum up business? What were your business sources, your lead sources?
That's a great question, and it's an ongoing struggle. One of the things that I have, having practiced law in this town for 36 years, I know a lot of people. I've had a lot of cases with a lot of people, and I've got a decent reputation. So I have worked on trying to spread the word to those I know who are business litigators in this community that I'm available to help with these cases. I've done targeted emails. I've done one mass mailing. I'm going to do another one later this year. And the other thing is that I have volunteered to do these things through the federal district court in order to get exposure to some of the litigators who I don't know, who are big firm guys, because I'm not a big firm guy, who can see me do what I do in person. So as an example, the case with the general and the prime, the law firm representing the plaintiff, the subcontractor in that case, is the largest law firm in Columbus, Ohio. And while I know a number of the partners at that firm, I didn't know the one that had this case. Now he knows who I am. He knows how I do these things. It's a good way to get your name out there and become known, even though it's a volunteer thing. You're not going to get paid for it on that first go round. But when they come back to you the second time and hire you, you will get paid.
Yep. And I would just say, before I go to Bill here, I see the hand still up. Ishmael, I would put a plug in for Natalie here, Natalie Armstrong Motan. If nothing else, I mean, her whole business is marketing mediators, arbitrators, people in the dispute resolution industry, but she has so many free resources where she's well worth the price of admission to hire her, that's for sure. But you can go to how to market my mediation practice.com, and there are all sorts of free videos and materials, things like that you might find helpful. Anybody would find helpful. I find helpful. So thanks. Okay, back to Bill. Bill, you have a question.
Well, I had a mediation of a business divorce, and it had a twist to it. It was a family business, two brothers who were splitting their business. It was a title company business. One brother, I'll call the cowboy, showed up very relaxed, boots, jeans. He was the guy who had started the business, but his brother was the financial guy who did all the numbers. They both thought that they were key to the business. I, in advance of any mediation, have a call with each counsel separately, and I asked them, do you want me to be a very evaluative, somewhat aggressive mediator or a message carrier mediator? And they generally say, no, we want you to push both parties hard. So we had a very brief joint session, and then I met with the plaintiff, who happened to be the business brother, and got pretty pushy on him. Then I went with the cowboy party, and the cowboy party said, we will not go back into joint session at all today. And I said, why not? And he said, because I know my brother and he carries a gun. And I saw his briefcase, and that's the briefcase where he often carries his gun. And it was a very intense dispute. And so I had to figure out, well, what do I do? And he cautioned me not to confront his brother. So I went and met privately with the suit brother's lawyer, explained to him that the other brother thinks your client's carrying a gun. He thinks it's in that briefcase. Can you talk to your client, take the briefcase out of the room? He can have whatever papers he wants in the room, but the briefcase needs to go, and you need to make sure he doesn't have a weapon on him. The lawyer did that. The briefcase went out to the car. The case ultimately settled. They both thought that they were the magicians of the business. So I suggested that they delete the non-competition clause in their original agreement, allow them both to operate the businesses. One got to keep the current business, paid a small amount to the cowboy. The cowboy got to start the business all over again, and it resolved. But that was an unusual twist. I've thought of putting in my mediation agreement that nobody can bring weapons to the mediation, but that seems a little too much. But it was an unusual twist.
That is unusual. You handled it well.
Yeah.
And you give me one more thought I'd like to conclude on. You see, I'm wearing a suit today, and it's not because of this presentation. I have a zoning hearing later today, and that's why I'm wearing a suit. I am typically dressed casually. The way Ishmael is dressed today is pretty much how you'll see me in the office anytime I'm not going to court. And when I am mediating, I will tell people up front, please don't feel like you need to wear a suit for my benefit. We're here to work. We're not here to have a fashion show. be comfortable, because we may be here for a while. So you might as well wear comfortable clothing, and you might as well be as comfortable as you can be while we're proceeding through these unpleasant topics and unpleasant tasks. And people seem to really appreciate that, because it says to them, we could focus on substantive things, and if I'm wearing jeans, nobody cares. And I think that's a good thing. It's not a bad thing at all.
Yeah, that's interesting. Okay, so at this point, we do have Teddy saying she does include a no weapons clause in her agreement to mediate. And I had not thought about that, although in my early years as a lawyer, I did have a couple of deposition witnesses with guns, which was shocking. But in any event.
I'm going to add it to my agreement. I'll tell you that.
Yeah, I think it probably depends by state. Here in Massachusetts, it's a standard thing that we talk about, that no weapons in the room. But I guess, it depends if you're a gun-friendly state or not. I wanted to comment. I thought your presentation was very interesting.
Thank you, Martin. Appreciate that.
I'm a more of a collaborative attorney. So I don't go as far as obviously the complete being a zealous advocate for any particular client. But as a mediator, many mediators learn facilitative methods, and what you've presented, puts that mediation method on its head, because I believe, and it is correct, that you need to be somewhat evaluative in business disputes, in particular in business divorces, but it's also extremely difficult to maintain that role of third-party neutral. And
It can be.
it's something that I've always been challenged with before I became a lawyer for the National Association of Realtors, and going forward, because you have knowledge of a business, the way a business works, or how something functions, I think for those of us who may be a little bit less experienced, you do sometimes need to stand back and say, before I speak it, does that impart any type of bias or preference to what the other party has said? And then I've learned to kind of put on that reflective hat, which is more of a facilitative method, just to kind of deflect my own personal, what I was going to say, and kind of put it back on the shoulders of the parties. Now I've only had, smaller type companies, but they are, family run businesses, and they do have significant issues. So, I think it's quite interesting in your presentation to extend that to, larger companies. And I do like that idea of bringing the significant others to the table also. I'm used to actually telling the attorneys, in session, when we're in joint session, you can, feel free to talk to your client, but when we're all together, I really prefer to hear directly from the parties. Because sometimes attorneys who are very zealous advocates continue to push their point to the point where we don't get anything done. So it's a skill, and I guess it's easier to tell your brother counsel or sister counsel to kind of stand back, but for a non-attorney mediator, I think it's important to have that skill also, is to say, up front, you really want to hear from the parties when we're all together.
And on that note, it is the top of the hour, And so that's it for this week. I thank you all for being here. I encourage you to donate to the Heart Market or to your favorite food bank. And most importantly, if you would let Natalie or I know the amount of your donation, then we'd be so honored and pleased to add it to our running total. Thank you. Now, next week, we have got a very special speaker, which I'll just take a minute here to mention. Oh gosh, Ken Feinberg. And so listening to Ken Feinberg is just an amazing experience. He's so worth your time. And remember, the clocks in the United States are being, well, at least in California, the clocks will spring forward Sunday night. So check your time zones and check your start time for 8 a.m. Pacific next Monday specifically, because other countries don't move, and even other states don't move at the same time. So 8 a.m. Pacific next Thursday, okay? So thank you so much for being here, everyone. We'll see you
Thanks.
next week, same
And
time,
thanks,
same place.
thanks for having me, and thanks for supporting Heart.
Yeah, a pleasure. Bye, everyone.